Good morning. Happy Monday. Welcome to the Courtroom Files Live. This is Judge Anna Marie Anzalone, where earlier this morning things got a little spicy in a friend of the court show cause hearing.
All right. So, Ms. Underwood, have you had a chance to speak with Mr. Doobie?
I have, Your Honor.
And how does your client wish to proceed today?
We would ask the court to enter a not guilty plea on Mr. Doobie's behalf. Mr. Doobie, Your Honor, has spent pretty much a large part of the last couple years in and out of incarceration and rehab.
I'm sorry. Listen, I'm about done. You don't get to sit there looking high and smirking in my courtroom. So sit there and be quiet. And both of you bring your partners just to create more issues, please. This is about you two and a child that you had together. And so you don't get to sit there with an attitude. Neither do you. And for you two that are here, you stay here, you be quiet, you don't get involved. Do you think this is funny? Because you've also had issues. So why are you smirking? Because he's been incarcerated.
I've had issues, but I've overcome my issues.
Good for you.
And
so
I'm
you
the
sit
one
there,
that
you behave in my courtroom, and stop smirking. So what do you want to do, Ms. Underwood?
Your Honor, Mr. Doobie is going to request a review. He is also actively looking for employment. He just recently completed rehab successfully, so he's ready to get out and attack this, Your Honor. So I would ask for a couple weeks for Mr. Doobie both to petition for a review and to present the court with evidence that he is actively seeking, if not has found a job.
Okay. All right. So I will set this over to July 14 with my other ones. By then you're supposed to have payment. You'll start making, have a job, start making payments, and then also request an income review. All right. So Miss Double, you have a seat there and you don't leave until
I'm not the one that's on trial.
I'm gonna, you're what?
I said, I'm not the one who's on trial.
But you're misbehaving. So have a seat. You two can leave the courthouse now. Thank you. And you will wait to leave the courthouse. So have a seat.
I'm gonna leave.
No, you're not gonna leave. I'm not gonna have a fight in my parking lot. Have a seat.
I'm trying to leave and go do my job.
I'm letting them leave and then I'm gonna let you leave. So have a seat.
Hold me in contempt because I'm trying to go work.
How long do we have to stay for?
3 minutes. 3 minutes for them to get out of the building into a car. So have a seat.
And Your Honor, just
One more.
so you know, Your Honor, just so you know, he's already successfully completed rehab.
Good.
More than once. And he just.
All right, I'm done. So have a seat and be quiet while I continue with my court. All right. We also have Whitney Holtz versus Timothy Holtz.
So you get the impression she's dealt with those people before and isn't impressed with them. Did you also catch where the person said he's successfully completed rehab more than once? I would argue if you've had to complete rehab more than once, perhaps they weren't all successful. Anyways, good morning again. Welcome to the Courtroom Files Live. Happy Monday. Thought I'd start us off on a spicy note. Let's tame it down a little bit, though, and we'll go to the usually even-tempered, somewhat jovial Judge Meineke.
Those tough times in the early 2000s. Does that make sense to you, Ms. Moore?
Yes.
All right. It's one thing when we could say, well, that was part of my past. It's very difficult to say, all right, well, this happened in 2025 and it happened then. So, you know, it's hard to then say it was part of your past, if that makes sense. So let's see if we can work together here. We'll order a pre-sentence investigation. My staff will reach out to you, Ms. Moore. Just as a reminder, staying away from all substances, alcohol, bars, clubs, those types of things, and make sure we stay on track with all of our bond conditions, okay?
Okay.
And Your Honor, could I just interject here? I just would like the court to know, at the time of the last pretrial, you did instruct Ms. Moore, to be communicative with pretrial services if there were issues regarding testing.
Yes.
There are issues regarding testing. I just like the court to know she is a mother of 3. She has a college student at Wayne State University. She also has a 12-year-old and an 8-year-old. And these are wonderful little children, wonderful students, 90th percentile in their class. Miss Moore, at the time of this case, Judge, she was employed. She was arrested. She was held in custody to essentially, be ready to be released the next day. She was picked up from another jurisdiction on a very, very dated case and was in custody for about 7 days. When she got out of jail, her job was gone. So now she's got 3 children, no job, and she was struggling to get on her feet financially. She has been really working hard to find a job, and it looks like finally, after a lot of interviews, she has a job that will start June 1st. She got her license as a phlebotomist, so that's fantastic. Furthermore, talking to her a couple days ago, Judge, she didn't have any lights. She's trying to keep basic utilities on. Today, she's sitting there with a paintbrush in her hand because she's painting her whole interior of her house to keep her house, which she owns and, is a very valuable asset to her. So it's not as if she's just sitting around doing nothing. She has wonderful children. She's working on getting employed. She's working on improving her house. She was hit by a drunk driver in January of 25. So she does not have a vehicle. So the date of this incident, in fact, she obviously Ubered to the movie theater. So if and when you're seeing any missed cases, she is trying to communicate with pretrial services. I know that with sobriety court, sometimes there's additional funding that can be helped. I don't want to put her on a sober link or anything like that, but if there's any sort of funding that could help her when it comes to testing, I just want to put all of that on the record. She's not trying to be non-compliant with the bond.
But Ms. Moore, have you been calling every day to test, even if you weren't able to go? Do you communicate that?
I do call, and it was up until maybe a week or so ago that I wasn't able to test, but every test that I have done has been negative. So it's just a transportation issue. Here's
what we'll do. So she's testing 3 times a month for drugs and twice a week for alcohol. And that works to be 11 times a month. I think it's time to reduce her testing.
Thank you.
And again, I don't have an updated pretrial services report from the last time we were together. So I'm going to take it as no news is good news at this point. If I do find out that there's been any positive tests, the court can always increase your testing again. But for now, I'll reduce your testing to simply 1 time a week.
Thank you.
I was only tested for drugs 1 time, and it was said that if that was negative, I would not be tested for drugs again.
Okay, so that's the update that I was missing. So my report said that you were had to test 3 times. And I, frankly, since I didn't get a new report, I was just sort of giving you the benefit of the doubt and was going to delete drug screens at this point anyway. It sounds like you did come back negative, which is good because that means that took the drug screens away for now. So, but the alcohol tests they're twice a week, and that's 8 times a month. And so I'm going to cut them straight in half. And we're going to go to once a week, which will hopefully save you financially a lot of money and aggravation. So, obviously, all other terms can continue. No bars, clubs, liquor stores, those types of things. But it doesn't sound like she really has time for any of that stuff right now, anyway. So,
right.
All right, you continue to do well in your testing, and I can continue to look at opportunities to further reduce your requirements testing-wise.
Thank you.
Thank you for bringing that up to my attention, Ms. Chappelli, and I don't have a problem with cutting it in half. Good luck.
I appreciate that. Thank you.
Yeah.
Thank you.
It is deja vu. We've seen her and that attorney before. But it is showing as live, so I don't know. Whatever. Let's go to Judge Washington and say good morning to her.
What's for the people?
Matthew Mansour on behalf of Ms. Velasco Romo. Ms. Velasco Romo, can you state your name for the judge, please?
Ana Velasco. Thank you. We're here for a pretrial today.
Yes, Your Honor, that is correct. At this point, we would like to set this matter for a final settlement conference, please.
Ms. Velasco Romo is aware that no further offers will be made after today.
Yes, Your Honor. And when I can, I would like to address bond, please.
You may
Judge, I
proceed.
just wanted to put the plea offer on the record. Plead guilty as charged with HIDA, restitution reserved, and referral to probation.
All right. So your client is aware she's turning down HIDA, which means that if she were to complete all of her terms, this wouldn't be on her record.
Your Honor, I believe both offices have been in contact with the complaining witness here. I believe the complaining witness has reached out and stated his position on whether he wants to proceed or not. So we would like, for the time being, we would like to request the no contact order to be changed to no unwanted contact if Ms. Woods can confirm that. The parties do have a newborn child together as well.
Looking right now. I can tell you that he's fine with a deferred sentence. I don't have anything in here that says he wants contact.
That's the case. I cannot grant the contact.
Yeah, I mean, we'd have to reach out to him and confirm that he does.
You parties can stipulate to it after the fact if they see that, if the prosecutor and the defense agree.
Thank you, Your
Otherwise,
Honor.
file another motion. There is right now consensual third-party contact for childcare that was granted at the time of arraignment. And Mr. Mansour, I'm not sure you completely confirmed that she understands that she's giving up her opportunity for HIDA.
Ms. Velasco Romo, you understand?
Yes, I understand.
Thank you.
We'll see you on June 27th at 9:30 for the final settlement conference, and then July 11th at 8:30 a.m. in person for the jury selection, ma'am.
All right, thank you so much.
Let's head south. Let's go to Bay County, Florida. This is Judge Brantley. Let's see what Florida man's up to this morning.
To do based on Mr. Davis's, and for the record, Mr. Davis has stood in front of the court, has not responded to the court's questions. I've reviewed the probable cause. I believe the alleged victim is the mother in the case, or no, is the mother, is that correct? And the law, of course, law enforcement is the victim of resisting officer without violence, and it sounds like Mr. Davis was kind of doing what he's doing now. So what I'm going to do, based on that, I am going to appoint the Office of Public Defender to represent Mr. Davis. Ms. Beasley?
Yes, Your Honor. Mr. Davis is here before you in case 250910. Do you want to take my card? He's refusing to take my card, Your Honor. We'll enter a plea of not guilty and we'll get an evaluation.
Okay,
scheduled.
we'll set him maybe for the June motion day. It'll be July, June maybe that's not enough. June 20th. Would that be enough time, you think?
It may be.
I will set it for June 20th at 9 o'clock to see if we have a report by then. All right, that will conclude the hearing. Mr. Davis, you can go back and have a seat. And for the record, Mr. Davis responded to that request to the court to go back and have a seat as soon as I said it.
Justin Pittman. Your Honor, Mr. Pittman's coming before you in case number 250832 and 250909. And information has been filed in both cases. We'll enter a plea of not guilty, demand for discovery trial by jury. If we could pass him to July so we can get some depositions done, there is a DOC offer.
July 24th at 9 o'clock.
Ayer Ortiz Sandino. Your Honor, he's here before you in case 25-1162, and information has not been filed yet. Today is his 30th day. If we could reset him for another arraignment date.
All right, we'll set him for the June 16th at 9 o'clock for allow the state to make a charging decision.
Have a seat again. Jonathan McPherson.
Barbara, thank you for gifting a membership. Very kind of you.
On one of Mr. McPherson's cases, 25-1132. The state was not appointed in 25-1071, 1072, 1073, or 1112.
I think the public defender's office is appointed on everything that's before me today was appointed on Friday.
Okay, wonderful. And so all the charges have been consolidated into 25-1071. We'll enter a plea of not guilty, demand for discovery, trial by jury. And we'll need to get some depositions set on that case. So if we could have your July date.
July 24th at 9 o'clock.
No. Okay.
Kevin Moore.
Morning, Your Honor.
Good morning, Mr. Overstreet.
Actually filed an information this morning.
I was wondering about that.
I don't know if it's hit the clerk because it was so fresh this morning.
It has not.
I have a copy for the report if I would like to see it.
Your Honor, Mr. Moore is before you in case 25-0933. We've been handed an information charging 3 counts, each of which are first degree felonies, but they're punishable by life. We would waive a formal reading, enter a plea of not guilty, subject to any pretrial motions, and ask for the next available court date. We'll file a demand for discovery immediately.
July, June, July, August,
I won't be here in June, so.
July.
Yes,
July
sir.
24th
That's fine, Judge.
at 9 o'clock.
And he's held without bond. I've talked to him about what we need to do, whether the information was filed or not. So there may be a forthcoming motion.
Okay, very good. All right, that'll conclude today's hearing.
Thomas DeStefano. Initials. Signature. Signature. Your Honor, Mr. DeStefano has a case in County Court 25-1542, and we'd submit a plea in absentia for your consideration. Your Honor, in case 25-0899, the state has now filed an information. We acknowledge receipt of that, waive a formal reading. We're prepared to enter a plea of no contest to that, as well as withdrawing our previously entered plea of not guilty, enter a plea of no contest to felony battery priors in case 24-2308. Both of those are third-degree felonies, punishable up to 5 years in prison, $5,000 fine, or both. The agreement we've reached with the state is he be adjudicated guilty as to each. He'd be placed on a period of probation not to exceed 36 months. Those sentences would run concurrent with each other. Court costs and fines would be in the amount of $1,028. Restitution would be reserved. There's 100 hours of community service work and a minimum of 8 hours a month. If he provides a doctor's note that he's unable to do it based on his health, I'd ask that those could be waived if it's sufficient. His cost of supervision would be $20 a month. He'd undergo a drug and alcohol evaluation and any counseling that's deemed necessary. There'd be zero tolerance for use of controlled substances. He'd be subject to random urinalysis at his own expense. Department of Highway Safety and Motor Vehicles may apply additional penalties. He'd submit to a DNA sample if required and forfeit any seized items. He'd undergo a mental health evaluation and counseling that's deemed recommended. He would be allowed to have peaceful contact with Brandis King. He would complete the batter's intervention program. He shall not possess nor consume any alcohol. We stipulate to the facts contained in the information filed and the amended information in the older case. They would approve a prima facie case. We'd waive a reading of any discretionary costs. We're unaware of any DNA if tested would assist the defense.
That's the agreement with the state?
Yes, Your Honor. And this is a best interest plea.
Raise your right hand. Promise to the testimony you're about to give the truth, the whole truth, and that the truth so helps you God.
Oh, my God. All right, sir, lower your hand and state your name, please.
Thomas Mitchell Destafino.
Mr. Destafino, you heard the announcement of Mr. Meredith. Is that correct?
Yes.
Is that your understanding of the agreement with the state?
Yes.
Has anybody promised you anything different?
No.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter this agreement or understand any of the terms and conditions of it?
No.
I've been handed a plea waiver consent form. There's the front page. On the second page is a signature of the defendant line. Is that yours?
Correct.
Have you had an opportunity to read that agreement?
Yes, I have.
Have you had an opportunity to go over your cases with Mr. Meredith?
Yes, I have.
Have you had sufficient time to speak with Mr. Meredith about your case?
Absolutely.
Are you satisfied with your lawyer's advice and counsel?
Absolutely.
You understand that by entering the plea, you're waiving your right to go to trial.
I do.
You're waiving your right to require the state prove the allegations against you.
I do.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
I do.
You're waiving your right to present any defenses you may have to the allegations.
I do.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Correct, sir.
You're waiving your right to testify to remain silent at the trial.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Correct.
Are you doing this for your own free will?
Yes, sir.
Mr. Destafino, do you feel the plea is in your best interest?
Yes.
Do you understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
And I'll accept the stipulation. I'll find it as a prima facie case. We'll find that Mr. Destafino's plea was freely and voluntarily made after consultation with his attorney. I'm going to accept it. He'll be adjudicated guilty of 2 counts of felony battery. On each of those, he's placed on a term of probation not to exceed 36 months to run concurrent with each other. He's assessed fines and costs of $1,028. Let's see. Is any restitution? I'm going to reserve on restitution. He must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections. I got 2 score sheets.
I think the second one is the correct one, Your Honor. The one that's entered 25,899.
$100 of community service work, minimum of 8 hours a month at through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that to at the direction of probation officer, Mr. Destafino. I also give the Florida Department of Corrections the discretion to waive that community service work based on a medical excuse. His cost of supervision will be $20 a month. Within the next 30 days, he must undergo a drug and alcohol evaluation, follow all recommended counseling. Also, within that 30-day period, and there'll be a 0 tolerance for use of any controlled substance not prescribed by a treating physician. He'll be subject to random UAs. Also, in that 30-day period, he'll undergo a mental health evaluation and follow all recommended treatment. Department of Highway Safety and Motor Vehicles may apply additional penalties. He'll forfeit any seized items. He'll write a letter of apology to Brandis King. He shall only have peaceful contact with Brandis King. Also, within the during his probationary period, he'll enter successfully complete the batter's intervention program. He'll not possess or consume any alcoholic beverages while on probation. Sir, you have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you and you can't afford one may be appointed to represent you at no charge. Good luck to you. You just step over, be fingerprinted, and speak to the probation officer.
Yes, sir. Good luck. Thanks.
All right. Well, they work to bring up the next contestant. First off, Axiom, welcome to channel membership, a certifiable law junkie you are now. We have a lot of fun. There's some extras. Go to your membership page on the Courtroom Files YouTube page, and you'll see everything you're getting now. But Bailey, you were asked about, or Barbara asked about the pre-show today, and Bailey said Mondays, I think it was a pilot run. Yeah, I mean, today was the first one, but every day that we have a live show, we will have a members pre-show. So there'll be one tomorrow and one every day. After the first week, we'll reassess and see if we need to change up how we do it. But it'll be every morning, 6:30 Pacific, 9:30 Eastern. Yeah, that sounds right. Half an hour before whenever this thing starts. Here in Arizona, we don't time change, so I lose track of time real easy. Quite honestly, I think the whole country should give up time change. It's silly. It doesn't save daylight at all. But that's another discussion for another day. So yeah, Axiom, feel free to join us tomorrow morning, a half an hour before this show, and join us for the members pre-show where we have fun. At least we did this morning, I think. We talked about a judge from Colombia as part of what we did. Good times.
Even if I found it, that it was sufficient to transport Mr. Gray to the Florida State Hospital. And if they get over there, or if they get that language and they don't accept him, we're another 2 months down the road. So I'm gonna go ahead and set this for June 20th at 9 o'clock for a competency hearing. Go ahead and appoint Dr. Schuler at this time to review that Mr. And basically what I'm doing now is to determine whether Florida State Hospital is the least restrictive measures available based on the language, based on life management indicating they cannot restore Mr. Gray to competency.
Yes, sir.
Now, if we, and I'll do my best to contact Florida State Hospital and see if that's sufficient, and if we can do it prior to that, I'll do that. And Mr. Gray, I know you want to say something. You may want to wait, and you may want to ask Mr. Meredith before you.
Yes, sir. Mr. Gray wants to resolve these cases, obviously, and
Mr. Gray, Mr. Meredith, there's nothing Mr. Meredith can do, and there's nothing the state can do. I cannot accept a plea, and I cannot resolve your case until I can find you're competent to proceed.
Yes, sir.
And if you don't take your medicine, I can't find you competent to proceed. So that's why I'm stuck. I can't do anything with you with your case. And I can't resolve your case until I can make that determination. And according to life management, if you don't take your medicine, you're not going to become competent. If you're not competent, we're just stuck. Does that make sense?
I'm taking my medication as usual. I'm taking my medication every night.
Okay.
And they bring it to me. I haven't missed a night from taking my medication.
Okay. Well, it might not be.
I don't know what's going on with life management, what they're telling y'all. But I'm speaking up for myself. I haven't missed a night of taking my medication.
I believe you.
I don't know where that's coming from.
Okay.
We gotta hurry up and get this resolved.
Hold on. Don't get upset.
I gotta get up out of this big kind of jail.
I understand. Listen to
You
me.
understand what I'm saying, Mr. Clark? I'm not
Yes, sir.
trying
Listen to me. Listen to me. It may not be you. It may be the medicine, but I'm gonna go ahead and fast track this. Okay.
Yes, sir.
I'm gonna put it on my fastest track I can.
Yes, sir.
Okay.
Yes, sir.
I'm gonna do the best I can. I can't promise you anything, but I'm gonna promise you I'm gonna work on it.
Yes,
Okay.
sir.
All right. We'll say if we can get you back before then, Mr. Meredith will put you on an earlier docket. Okay.
Yes, sir. You think you put me on earlier docket, Mr. Man?
it depends what Dr. Schuler says, okay?
All right. All right.
Thank you, Your Honor.
We have,
You're on the Spanish,
yes,
Fine,
wait,
sir.
Mr. Ricardo is present. If you go ahead and call your client.
Miss Benitez?
Axiom, thank you for the $2. I appreciate it. Yes, Ellie is in the studio now, and she is full of it this morning. So if the stream suddenly cuts out, it's her fault. Yeah, there she goes, right for the network cables. Say good morning. Anyways, I'm going to try to control her. If the stream does cut out, just stick with me and I'll bring it back. But she's interesting this morning. Let's, as long as I hit the pause button, let's do this. Let's go to Texas and we'll say good morning to Judge West.
Did you hire someone? Okay, so what I'm going to do, Mr. Gobert, is reset your case for about 30 days to give you some time to see if you can get someone hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers you talked to, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? If you'll step in front of the clerk right here, she'll give you that reset notice. Jamarcos Zarate Jones. Jamarcos Jones. So the one that says in treatment, did we, you can go.
Thank you, sorry.
That doesn't mean.
No response, Your Honor.
This bond will be forfeited for non-appearance and reset at 100,000. Lauren Bridges, if you'll call the name Lauren Bridges, please.
Lauren Bridges.
I mean, she went in May 16th. No. She didn't call last week and say, can I?
I just told the bondsman I'll let you know. So I don't know. No response, Your Honor.
Yeah, I mean, she sent me, she went into rehab Friday. So, her bond will be forfeited for non-appearance and reset at 100,000. And then if she calls her, they can get in touch with her, maybe tell the bondsman if they'll get her here next week. I'll maybe recall it, but she doesn't get to just go. Yeah. But we can let her, call her and get her here. Ronnie Oliphant. Good morning, sir. Are you Ronnie Oliphant? And Mr. Oliphant, looks like this is your initial appearance. Hold on a second. In cause number 25, DCCR 0379, you're charged with the third-degree felony offense of injury to a child, elderly, or disabled individual from February 18th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, I had one, but released him, but I was trying to see, can I get a lawyer on my own? I had a court-appointed attorney.
Yeah, so that's what I want you to do is hire your
Yes,
own
ma'am.
attorney if you can. So what I'll do is reset your case about 30 days to give you some time to try to hire someone.
Yes, ma'am.
If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you your reset. Lisa Pratt.
Pretty good, thank you.
Good morning, ma'am. Are you Lisa Pratt?
I am.
And Ms. Pratt, this is your initial appearance. In cause number 24, DCCR 1460, you're charged with the state jail felony offense of theft with previous convictions, and that's from April 1st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
They assigned me a lawyer.
They did. So when you're in custody, we give you a court-appointed attorney, but now that you bonded out, what I do is expect you to at least try to hire your own. So I'm going to reset your case for about 30 days to give you some time to try to hire someone.
Okay.
If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. You need to bring me back the names of the lawyers that you've talked to, so I know you're trying. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. Do you understand?
I do.
And are you working?
I'm on disability.
You are. If I test you this morning, you gonna have anything in your system?
I do. No.
Have a seat in the jury box. Let's double check what you got in there. Have a seat in the jury box. Carnell Beard. Good morning, sir. You're Carnell Beard?
Yes, ma'am.
Did you get someone hired?
No. I've spoke with, Kevin Lane, Ms. Holmes, Mr. Smith. What they asking me for down, I barely make that a month. I can show you my check. I work for
Well,
the city of Bloomington.
let's do this, Mr. Beard. Thank you for visiting with some attorneys. I'll have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to make sure to fill it out accurately and completely because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. Okay? Step in front of the clerk. She'll give you that paperwork.
Let's head back to Michigan, Wyandotte to be specific. This is Judge Elizabeth DeSanto. We first visited with her last week, and we have deemed her to be Judge Mom. So let's see what's going on with her today.
Do you have paperwork on any of the ones you have? No. No, okay.
All right, so Mr. Swallow, we called the matter of Johnny Behringer III. Is Johnny Behringer III in here? Bennett,
Say, I didn't recognize that name. No, he was in the, I was told not to bring any clients in, Your Honor, but I will certainly get him.
Okay.
Mr. Bennett, just come up, please.
Please take your hat off. You're in court. All right, so we are on the record the matter of the City of Riverview versus Johnny Bennett III, 221484.
Yes, ma'am. Good morning. Your Honor, good morning. Richard T. Serrano, P33828. Today, Your Honor, I appear on behalf of with my client, this being the date and time set for arraignment pre-trial, and I have explained the nature of the charges against them. Thereby, we waive formal reading today, stand mute, pass for a plea not guilty.
All right, and so today is the date, and I'm sorry, your name for the record, sir?
It's Johnny Mayes Bennett III.
All right, thank you for dressing appropriately for court as well. And so today is the date scheduled for the arraignment trial, finally. And so the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask for the pretrial counsel.
Your Honor, after the pretrial matter with the prosecutor, my client is going to avail himself of the offer made in that he will plead responsible to an amended charge of expired plate. He understands what that entails. He'll be able to pay that today out of the bond that he's posted, a 5,000 10% bond. He's posted in his name. So if that's accepted by the court, then, Your Honor, we should be able to take care of this matter today.
All right, please raise your right hand. Do solemnly swear or affirm the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth?
I do.
All right, you heard the plea that was placed on record, correct?
Yes, ma'am.
As to the amended charge of expired plate, how do you plead?
Responsible.
And you've gone over your rights with your attorney, correct?
Yes, ma'am.
And you understand all of your rights?
Yes, ma'am.
You also understand by entering into a plea that you'll be waiving some of those rights?
Yes, ma'am.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes, ma'am.
Knowing all that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
Any immigration issues?
No, ma'am.
All right, the court will accept your plea as knowing and voluntary. The court will dismiss the original charge for the plea agreement. And that's $100. There's also a warrant fee and a clearance fee. For sure a warrant fee. I think there may be a clearance fee, but so the total is $195. So what we'll do, sir, is we will apply your bond that you have previously posted. There's less than 10%, so your bond balance is $450.
Yes, ma'am.
And we will apply the bond balance, and then you will receive the difference in a refund check mailed to your home. And you're in the apartment in Southgate, correct?
Yes, ma'am.
Okay, so what did take you so long to get here to court, sir?
I believe the court had my wrong address and I just never received notice to come in.
Your Honor, he
In
no
the
longer
future,
has
sir.
a vehicle.
What's that?
He no longer has a vehicle, that was the
Okay.
question.
Right, in the future, in the event that you, have police contact and you don't receive anything, you should always reach out to the court,
Yes, ma'am.
okay?
Will do,
All right.
ma'am.
Have a good day.
I appreciate it. Thank you, ma'am.
Thank you.
Good luck.
All right, we are on the record in the matter of the city of Riverview is Tracy Duda, 25345.
Your Honor, Richard T. Serrano, P33828, appearing on behalf of Ms. Duda. Your Honor, I noted in the file that this matter was to be McNally process. The prosecutor is making that motion. If the court looks at the text of the letter.
I'm sorry, can you have Mr. Carmen, where's Ms. Duda?
That, I don't know, Your Honor. She had no phone number in the file. I couldn't contact her. The bottom part of that letter, if you look at it, says, Mr. Carmen, please dismiss this case. And I don't know if Ms. Duda or not has to appear, or some words to that effect. So she probably thought she did not have to appear since this was going to be resolved, but if you'd like to.
So the court does have, communication between Ms. Shelton and Ms. Pascuzzi from the Riverview Code Enforcement Department asking to dismiss the ticket for Ms. Duda. The problem is that it wasn't just a civil infraction, it had been issued as a misdemeanor, and so therefore the court can't just dismiss the ticket. So, your client still needed to be here.
I agree, Your Honor.
And your client has been here a number of times and her contact information is in the court system. I know that.
Do we have an adjournment, Your Honor, so they can contact her again?
So you can contact her again, you said?
Well, I have no way unless I write her a letter, but there was no file or email.
Mr. Goldbaugh does that.
Your Honor, sometimes that doesn't get timely.
So here's what I'm going to do, counsel. I'm going to ask that you, before you leave today, stop at the window and have somebody pull her name and some of her other prior cases to see if her contact information is in the system, okay?
Okay, I will. Do we have a specific date you'd like to adjourn to?
Let's see here. Good morning, Mr. Carmen.
Good morning, Your Honor.
All right, so counsel, I'll adjourn this 3 weeks, so that way if you're sending a letter, that'll give plenty of time.
Okay, thank you, Your Honor.
So that would be June 9th. June 9th, and you're here that day.
Thank you.
And we'll do it at 9:30 a.m. Okay?
Yes,
Thank you.
Your Honor, I will follow up on that, thank you.
Okay, thank you. All right. And
let's go back to Florida, where we were earlier with Judge Brantley Clark.
An evidentiary hearing.
Yes, Your Honor.
Your Honor, can we also set a preliminary BOP date?
Yes, we'll set it for that date also.
Casey Brewer. This is with Mr. White. Your Honor, this is Casey Brewer. She's here before you in 2 cases, case 24-2112 and 25-974. She's going to be withdrawing or be entering a plea of no contest as follows. In case 24-2112, count one, domestic violence, battery by strangulation, a third-degree felony, maximum penalty 5 years in prison. Driving while license suspended, revoked, habitual, a third-degree felony, maximum penalty 5 years in prison. Case 25974, the charge would be DUI, a second-degree misdemeanor, maximum penalty 6 months in the county jail, and refusal to submit to a breath test, a first-degree misdemeanor, maximum penalty a year in the county jail. On the misdemeanors, she will be adjudicated guilty on both of those and time served. On the felony case, she will have adjudication withheld on both of those felonies. She'll serve 60 months on probation, court costs and fines of $1,028 to be paid over that probation period, 100 hours of public service work, 8 hours a month, $20 a month cost of supervision, a drug and alcohol evaluation, and any counseling. Enroll within the first 30 days with random UAs at her own expense. We'll stipulate to the facts. For purposes of the plea, Department of Motor Vehicles may apply additional penalties. She'll provide a DNA sample, forfeit any item seized. She'll have a mental health evaluation and counseling as deemed necessary. No contact with any victims. She shall not possess or consume any alcohol throughout the period of probation. She shall complete the batteries intervention program at her own expense, enroll within 30 days, and all remaining counts are consolidated. That has been completed, and the cost form is signed, and I'm passing that forward.
That's the agreement with the state?
Yes, Your Honor.
Raise your right hand. Honest swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, Ms. Brewer, you lower your hand and state your name.
Casey Brewer.
Ms. Brewer, you just heard the announcement of Ms. Beasley. Is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understanding the terms and conditions of it?
No, sir.
I've been handed a plea waiver and consent form. There's the front. Second page is a signature of the defendant line. Is that yours?
Yes, sir.
Have you had the opportunity to read that agreement?
Yes, sir.
Have you had the opportunity to go over your cases with Ms. Beasley? Excuse me.
Yes, ma'am.
Have you had sufficient time to speak with Ms. Beasley about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that being in this plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses you may have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Ms. Brewer, do you feel the plea is in your best interest?
Yes, sir.
You understand, by entering the plea, you understand. You lost my phone. You understand by entering the plea, you're waiving your right to go to trial. You're waiving your right to have your attorney cross-examine the state's witnesses. You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will? Ms. Brewer, do you feel the plea is in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea? All right. I'll accept the stipulation. I'll find there's a prima facie case. I'll find that Ms. Brewer's plea was freely and voluntarily made after consultation with her attorney. I'm going to accept it. As far as the domestic violence and battery by strangulation, adjudication of guilt is withheld. On the driving while license suspended or revoked, habitual offender, adjudication of guilt is withheld. On she is adjudicated guilty of driving under the influence and adjudicated guilty of refusal to submit to breath test. On each of the felonies, she's placed on a term of probation not to exceed 60 months to run concurrent with each other. She's assessed fines and costs of $1,028. There's no restitution applicable in the case. She must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that at the direction of a probation officer. Her cost of supervision will be $20 a month. Within the next 30 days, she must undergo a drug and alcohol evaluation, follow all recommended counseling, zero tolerance for use of any controlled substances not prescribed by a treating physician. She'll be subject to random UAs at her own expense. Department of Highway Safety and Motor Vehicles may apply additional penalties. If she's required to give a DNA sample, she must submit one. She'll forfeit all seized items. Also, within the next 30 days, she must undergo a mental health evaluation, follow all recommended counseling. She shall not possess or consume any alcohol while on probation. She must enter and successfully complete the batter's intervention program. on the DUI and refusal to submit breath test. She's already been adjudicated guilty. She's sentenced the time she served in the Bay County Jail, given credit for that time. The sentence was run concurrently with each other and concurrent with the probation that the on the felonies. The state has consolidated any other accounts. Have I left off anything?
No, Your Honor.
Ms. Brewer, you have 30 days to file a notice of appeal. If you wish to appeal your judgment and sentence, if you'd like to have an attorney to represent you, you can afford one. One may be appointed to represent you at no charge. Good luck. You need to step over and be fingerprinted on that DUI. Wilson?
Thank you, Honor. Good morning.
Good morning.
Mr. Bitt. Coming before you is Sean Bitts, case number 241047. Charged with a 2 counts of trafficking. We will waive a formal reading and arraignment, enter a plea of not guilty to both counts, and just request to participate in discovery. Your Honor, this is going to take, I believe, taking a look at it and reading the affidavit, it's going to take some deposition. So I think we need at least 2 months, if not.
All right. July 24th at 9 o'clock.
We have to see it as soon as I get a chance. All right. Mr. Hagler. Coming before you is Malcolm Hagler, several case numbers. First one is the arraignment on case number 25984. And we will waive a formal reading and arraignment on that case, enter a plea of not guilty, and request to participate in discovery. And he has, along with those, several violations of probation, 2059, and excuse me, just 2, and 2921. We'll ask that those track in this matter, Your Honor. And in this case, I think, despite the seriousness of what it appears to be the charge, I think this case is very resolvable in talking with the prosecutor. So if we could have your next month's.
We'll set it for June 19th at 9 o'clock. And for the record, I got a email this weekend from Cornell Brock in regards to his living situation. I forwarded it to Ms. Nelson. Now I'm going to have her placed in the court file and forward it to both of you.
Thank you.
Okay.
Your Honor, my client has also asked if the court would consider reinstating his
No, not at this time. I'll deny that oral tennis motion.
Yes, Your Honor. I don't have one on me. I'll give you my name and number in a minute. Mr. Taylor. I think he has 2 cases. My docket only printed 1. And before you is Anthony Taylor in case number 25976. I feel like I read that there were 2 cases this morning, but my docket only printed 1.
There's a 25777.
And I apologize. For some reason, it didn't print. Also on that.
There's only 1 on the docket today.
Oh.
Yeah, the 25.
Should be
I know.
260.
We've got 2596 for today. He's got 251290 set for 616. You got 251295 set for 616.
He's already been arraigned on those other 2?
No, he has not been arraigned. Looks like their information has been filed on 2019 1290. And let's see.
Thank you, Darren.
And also on this, is it? It's also been filed on, and Mr. Wilson, so if you want to go ahead and.
Yes, Your Honor, that would be, I think that as long as that's okay with you, Madam Clerk. Yeah, I can, because I've.
Well, as long as it's okay with me.
Well, both of them. I try to get consensus here, because either one of you can make my life miserable.
Me too.
Thank you.
Yeah, that's fine. Let's go ahead and arraign him on all, the informations have been filed, so go ahead and do that.
Yes, Your Honor, I will arraign him, because I thought they were all 3 on the docket this morning. I reviewed them all. I will enter a plea of not guilty on all of them, request to participate in discovery, and just ask for, Your Honor, I think the next court date is going to be too early. I'll go out and talk to him, and if we can get a resolution, I can put him on the WOW docket. I think July is more reasonable.
July 24th at 9 o'clock.
And I'll go out and talk to
Your
him.
Honor, Your Honor, I have something I would like to state for the record or whatever.
All right, anything it's not going to matter. Anything I do today, and it's.
I know, I was just going to ask if maybe, because I got, my case is kind of complicated or whatever. I experienced a traumatic brain injury
Like I had a gash this big in my forehead when I was arrested with blood all over me and stuff. And I've already been to Florida State Hospital a couple of times for competency restoration and stuff like that. I know that I already had the one docket set for the 16th of next month or whatever. I would like, if there's a possibility that y'all can give me that, that date or one a little earlier, I would be grateful. And I think that Mr. JP needs to know that on one of my charges.
Don't talk about your cases.
Well, I'm
Just
not
look,
talking
listen,
about
I
my
mean,
case.
You're not accomplishing anything. Just
I know, I just wanted to let him know that the supposed victim in the case received the other $1,000 worth of property that was missing.
All right,
That-
yeah, look,
all
you're
of the
not-
property was retrieved.
That concludes your hearing. And if Mr.
Sir?
If Mr. Wilson feels that he needs to file any kind of motions, he can get on an earlier docket. Okay?
That's why I want to go out and take a look at it to see if I need to file a competency. I represented Mr. Taylor before and what he's talking about, so I just want to see if there's still an issue.
So what is it, June 16th?
No, we're not, the June 16th is our arraignment docket. There's nothing, and he's arranged it today. So Mr. Wilson's going to see if he needs to file a motion. And then if he files a motion, it'll be on an earlier docket.
All right. Can I find out what my bonds are? Because I haven't been to first appearance yet. Like, what's the price of my bonds and stuff? Because of the head injury, they didn't allow me to go to first appearance. It isn't even healed up yet, but I just need to know, like, what's my bond? And do I need to get a court order to use the telephone to post my
You
bond?
got no bond right now because of the new charge.
You're held without bond.
You're held without bond.
On all my charges or just?
Well, on 976, so it doesn't matter what the bond on the other ones are, as long as they were revoked, so you're held without bond.
The bond that I paid was revoked?
Yes, sir. That's the one that would be revoked.
Okay, so that.
Okay.
You're held without bond. I think that's all I have. I've got one more in your box. Well, I'm still waiting on one more.
Okay.
Mr. Price. Ms. Steptoe.
Is this Shawnee Steptoe, STEP?
So while we're waiting here, Bailey and Ashley, since we're talking a whole lot about AI, what do you say for tomorrow's pre-show? We dig into AI a little bit. Let me know if you'd like to do that. And if you want to join us on the pre-show, you need to be a channel member. $2.99 a month, you get that and so much else. There is a link in the pinned chat for that. Love to have you as part of that community.
Yeah.
There you go.
This is Shawnee Steptoe, case 251185. State's filed a 2-count information. We acknowledge receipt of that, waive a formal reading, prepared to enter a plea of no contest to count 1, possession of methamphetamine. That's a 3rd-degree felony, punishable up to 5 years in prison, $5,000 fine or both. Possession of paraphernalia, count 2. On the plea form, it says felony, but I think it's a misdemeanor. Punishable with county jail time. The agreement reached with the state is on the misdemeanor, she would be sentenced to time served. On the felony count, adjudication be withheld, should be placed on a period of probation not to exceed 18 months. During that time, she paid court costs and fines of $1,078, performed 100 hours of community service work at a minimum of 8 hours a month. Her cost of supervision be set at $20 a month. She'd undergo a drug and alcohol evaluation, any counseling that's deemed necessary. There'd be zero tolerance for the use of controlled substances without a prescription and random urinalysis at her own expense. She'd submit to a DNA sample if required and forfeit any seized items. We'd stipulate to the facts contained in the information filed under oath. We'd waive a reading of any discretionary costs. We're unaware of any DNA, if tested, would assist us in the defense.
That's the agreement with the state?
It is, Your Honor.
Tommy, swear to testify you're about to use the truth.
Yeah.
All right, Ms. Steptoe, you can lower your hand and state your name.
It's Shawnee Steptoe.
Ms. Steptoe, you heard the announcement, Mr. Meredith. Is that correct?
Correct.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understanding the terms and conditions of it?
No, sir.
I've been handed a plea waiver consent form. There's a front page. On the second page is a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your case with Mr. Meredith?
Yes, sir.
Have you had sufficient time to speak with Mr. Meredith about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by entering the plea, you're waiving your right to go to trial? You're waiving your right to require the state prove the allegations against you? You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence. You're waiving your right to present any defenses that you might have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes.
You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make. You're waiving your right to appeal anything but an illegal sentence. Are you doing this for your own free will?
I am.
Ms. Steptoe, do you feel the plea is in your best interest? You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea.
Yes, sir.
I'll accept the stipulation. I'll find it as a prima facie case. I'm going to find that Ms. Steptoe's plea was freely and voluntarily made after consultation with her attorney. I'm going to accept it. Adjudication of guilt is withheld as to the possession of methamphetamine. She's adjudicated guilty of the possession of paraphernalia. On count one, she's placed on a term of probation not to exceed 18 months. She's ordered to pay fines and cost of $1,078. There is no restitution applicable in the case. She must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that to at the direction of a probation officer. Her cost of supervision will be $20 a month. Within the next 30 days, she must undergo a drug and alcohol evaluation, follow all recommended counseling, zero tolerance for use of any controlled substance not prescribed by a treating physician. She'll be subject to random UAs at her own expense. If she's required to give a DNA sample, she must submit one. She'll forfeit any seized items. On the possession of paraphernalia, she's adjudicated guilty since the time she served in the Bay County Jail. Given credit for that time, the sentences will run concurrent. Ms. Steptoe, you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you. You need to step over and speak to the probation officer.
Look. This lady right here. Yeah. Miss Rowland.
Let's switch it up a little bit. We'll go back to Judge West for a little bit.
This is Mr. Smith's.
Mr. Smith. Oh, okay.
Good morning, ma'am. Are you Daisha Mark? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Mark, in cause number 24, DCCR 1912, you're charged with the third-degree felony offense of injury to a child, elderly, or disabled individual from July 17th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Samuel? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for an 8-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Ms. Mark is not competent?
There's none, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that we can get the probation department to do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right there. Okay? We'll see you back at sentencing.
Thank you, Your Honor.
Thank you, Mr. Samuel.
Am I free to go?
Yes, sir. Mr. Parker, on Rochelle Manuel. Same. All right, ma'am, again, you're Rochelle Manuel, and will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Manuel, in cause number 24, DCCR 1050, you're charged with the second-degree felony offense of aggravated assault causing serious bodily injury from April 5th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like that agreement's for a 3-year term in prison. Is that your understanding? And it's your understanding I'm going to take the plea today, I'm going to reset it for sentencing next week.
Yes, ma'am.
And we'll talk about some important things about that in just a minute, but that's what you want me to do, correct? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
All right, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Manuel's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, but I'm going to hold that and I'm going to reset your case for 1 week for sentencing. Actually, I guess we could do it on Tuesday. We don't have a Monday docket. Is Tuesday big? Should we do, I'm going to reset it for 2 weeks. I think that'll be easy. No, let's do it next Tuesday.
Yes, ma'am.
June's 2 weeks. Okay, we're gonna reset you for 2 weeks so that you come back on a Monday.
Yes,
Because we don't have a Monday docket next week.
Yes, ma'am.
So a couple things about that are very important. Obviously, if you don't show up on the 2nd to turn yourself in and for me to sentence you, this plea agreement's gone and things could be a whole lot worse. You understand?
Yes, ma'am.
If you're arrested for anything between now and that court date, things could obviously go bad and I don't have to accept the agreement. You understand?
Yes, ma'am.
All right, we'll see you back then on the 2nd at 9 o'clock.
Yes, ma'am.
Okay, thank you.
We just need to go through the motion of Gustavo.
Okay. Gustavo Chavez, 23-41422. Vasquez.
I will say, well, good for her on reaching a deal. It's going to suck the next 2 weeks with a sort of Damocles hanging over your head, isn't it? I would not want to be her. Anyways, back to Judge.
But I thought that's what you said.
I thought I did, but I don't know. I might have said.
I don't know.
Good morning, sir. You're Gustavo Gomez Vasquez.
Yes, ma'am.
And,
Oh, she said chop it. Yeah.
oh, I did? I just totally renamed you then. I'm sorry.
We have that Gustavo chop.
I do. I have that name, so hold on just a second. Let me get this pulled up the right way.
Oh. I didn't give you.
On the last one.
Oh, did they?
Oh, they didn't
Oh, I didn't
sign
get her to
it.
sign it. I'll bring back your sentencing.
Okay. All right, Mr. Gomez Vasquez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. And will your client waive the formal reading of the motion?
You will, Your Honor.
I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation March 11th of 2024 for the second-degree felony offense of indecency with a child, and that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to successfully enter and complete an approved sex offender treatment program. Is that true or not true?
The program,
Mhm.
I'm going to those classes.
Just, is it true or not true? If it's not true, then we'll just have a hearing. Okay. Not true to count 1?
Yes, ma'am.
All right. Count 2 alleges that you failed to register with the sex offender tracking program. Is that true or not true?
No, it's true, but
Okay. So did you enter your plea of true to count 2 freely and voluntarily? And because count 2 is true. All right, then I'm going to find that you entered your plea of true to count 2 freely and voluntarily. Find that count true, find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case for a sentencing hearing. Mr. Hoffpower, you can bring whoever with regard to count 1, please.
Probation officer.
I don't anticipate that would be long, so
No.
we'll just do it on a regular day.
Just for the record, so he understands, what I've explained to him, I explained to the court, is that he has explanations of things he's done. And
Sure.
I said, but it's whether you did this or not. And so he has some reasoning or explanations for all this. Which I
We'll
told
get
the
the
court will hear.
explanations at a sentencing hearing. And so what'll happen is I'm going to have probation do an updated pre-sentence report before sentencing. That'll give me more information about what's been going on. And then when we come back, Mr. Parker will be able to present to me anything you think is important on your behalf. Mr. Hoffpower will be able to bring any witnesses with regard to that count, and then I'll decide what to do on that day. Okay? All right, you are free to go. Thank you.
Thank you.
Barbara, thank you for the $10. Very much appreciate that. That's going to go directly into Ellie's Trito fund, though she has to share with Io, of course. But I actually had to go wake her up to bring her out for you, so she earned it. Again, thank you so much. It's appreciated.
Ms. Holmes, you have Shalora Dawson. It's a sentencing. No, just put her in jail.
Specifically, Bailey, I fell in love with this cat. Not that I don't like Io, and not that I don't like Jelly Bean, who we had before both of them. But this one, the amount of loyalty that I have out of a cat is just unheard of. She guards me at night, and as you can tell, she's always wanting to be by my side. Yeah, don't you? And I've never seen a cat like her. So anyways.
On my thing, she told me to tell the truth.
Yes.
I bought from the dispensaries and everything, but she said that
But
THC.
right. So did they tell you probably shouldn't be doing that so you don't test positive? So I don't think you're using something illegal?
No, because it wasn't me smoking, it was something like a gummy that was supposed to help relax me.
Right. But if it's going to test positive, then I'm going to assume the worst. So we'll get to that in a minute. I want to test you this morning, see what's in your system, then we'll go forward in a minute. Have a seat over there in that jury box. Willie Richards, Ms. Holmes, it's a sentencing.
He's outside.
Willie Richard.
Just, I've got my stuff, I've already dismissed, there was 2 of them, and I dismissed one of them outright, the other dismissal.
On Richards.
Just follow on Richard.
It's already been dismissed, it looks like, because it's not on the docket. Good morning, sir. You're Willie Richards. Mr. Richards, you were previously in court, entered a plea of guilty to the 2nd-degree felony offense of indecency with a child by sexual contact. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, sir.
Are there any additions or corrections?
No,
No, just had a couple questions.
Okay.
In regards to the supervision plan, Mr. Richards, he plays the drums at his church every Sunday. Does that need to cease, or we were just needing clarification so he's not in violation?
At a regular service or something specifically with regard to kids or?
At regular church service on Sunday.
after they get to her.
The guitar, I'm sorry. Guitar.
Okay. Yeah, I'll look at that in a second. Anything else that you?
And the polygraph, we were just wondering what that was.
That's part of probation for any sex offender.
Oh, okay.
Yeah.
That was it.
That is to make sure that they're doing what they're supposed to and not doing what they're not supposed to be doing. I'm assuming, Mr. Hoffpower, that you've visited with the family and I would think that
There is if you read the order, there is a restraining order for the complex which occurred.
Right.
And it's in place.
Well, and I would think that somewhat the special needs of the victim is why this offer was made.
Yes, sir.
I mean, Mr. Richards, this is, you're 60?
Yes, ma'am.
what you did was ridiculously terrible to a young girl that already has her own set of issues. All right. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine, and you're ordered to follow all of the rules and conditions of probation. That includes obviously being on the sex offender caseload, following all of those recommendations. I will allow you to play in the band at church. You are, however, specifically ordered, and part of your probation is you cannot be alone with any child under the age of 18. Period, ever, never. Do you understand? You obviously cannot be on the premises of the Carlisle apartments. You can't be anywhere near or have any contact or communication with the victim in this case as well. If you do everything you're supposed to, get the treatment that you're supposed to get, make sure that you're doing all of that, then this is an incredible opportunity because you do not have this conviction on your record. And if you successfully complete the probation at the end, the case is dismissed and you will never have this conviction. The other side of that, though, is if you violate any condition of probation, you will be brought back into court, you will be found guilty, and then I can sentence you to prison anywhere in the range of punishment, which is up to 20 years in prison. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. All right, good luck to you, sir.
Yes.
You've got Daryl Spencer, Ms. Holmes?
Yes.
Daryl Spencer?
So Jim asks, why is the prosecutor making that deal? Could be several reasons. It could be that there's some problems with the facts in the case. It could be witness issues. It could be, honestly, a prosecutor looking for an easy win without having to put in a lot of work. Because at the end of the day, for the prosecutor, it's still a W. I don't agree with it all the time, but that's how a lot of them approach it. As a win is a win, so I don't know. Anyways.
Okay. He said he has a traffic ticket warrant, so you'll have to go in today. All right, you're Daryl Spencer. And Mr. Spencer, you're charged here with possession of marijuana as well as evading arrest or detention with the use of a vehicle. And is there an announcement?
Not yet, Judge.
Okay.
I need to meet with them.
So I'm going to do a normal reset about 30 days. So you'll go in custody today. If you set out your tickets or pay them, whatever happens, that shouldn't take that long. As soon as you're out, the first thing you do is contact Ms. Holmes so you guys can go over whatever it is she knows about your case, and we'll see what the announcement is at the next court date. All right, you can go back with the bailiff. Ms. Pratt, are you gonna be able to use the restroom this morning?
Well, I was gonna talk to you about my medical.
Okay,
I don't know. They told you.
they did, but I know that even with that issue, you still go to the
Yeah, about every
restroom.
3 days or so, yeah.
So why are you,
We
come
can
up,
draw blood, I mean.
well, we're not gonna draw blood. Come up here.
Put your water here. Oh, my water.
Yes, you're gonna go before the judge?
When's the last time you smoked marijuana?
It was one of those little gummy things from the vape store.
Uh-huh.
I guess it's THC, but.
Why are you-
I just said marijuana, but it's THC, which I thought was the same.
It is the same. It'll show positive.
Okay.
It's all derived from the same stuff, and if you have a felony court case pending, I would think you wouldn't want to have anything in your system that would have you test positive, right?
Well, I'm not sure if it will. It was like a month ago. I'm on probation. I've been on it for almost a year.
Where,
It's in
from
Jasper
where?
County,
Okay,
and, they know about all my medical. I need a heart valve replacement, and I have liver failure, and now it's resulted to the kidneys.
okay.
So, he-
Sounds like you need to quit doing stuff to get yourself in trouble so you can
I do.
stay
I
out
do,
and
like,
take care of yourself.
I do, I know.
So, what I'm gonna do this morning, Ms. Pratt, is reset your case for you to hire a lawyer. You need to
Right.
try to get a lawyer hired before the next court date.
Okay.
If you do, bring the reset notice to them, and they'll tell you what you need to do. I'm also ordering, as a condition of your probation, that you have a drug patch. You need to have a drug patch put on within 24 hours. And you will, probation, when you're walking out, the lady sitting at that desk can give you a list of places where you can get that done. You have to have it on, you wear it 2 weeks, you have to show up every 2 weeks to have it tested. If it's not testable, I'm gonna assume it's positive. If you don't go show up when you're supposed to or go get it, I'm going to assume that you're using something that's illegal. Your bond will be raised and you'll be in jail. Do you understand?
I do.
Okay, so you need to have that on within 24 hours. So by tomorrow, you need to have the drug patch on.
Okay.
And then obviously don't use anything that could potentially test positive for anything. It's that
Yeah,
simple. If
okay.
you're on a probation and you've got a felony pending, you need to be crystal clean, all right?
Like 10 medicines that I'm on now.
If you are on medication that shows you to test positive, that's one thing. A gummy from the corner store is not medication, right? So bring your list of medications if you test positive, show them. We understand. I know what things test positive for other things, but gummies aren't one of them. All right, step in front of the clerk. She'll give you your reset notice.
Make that a condition of her bond, because I can't do anything with her probation in Jasper.
Yeah. It's just a bond here.
Okay, condition of the bond.
Yeah, did I say that the other way?
Yes, ma'am.
Condition of bond.
That's okay, just making sure. And sign it and talk to my lawyer about it. Well,
Mr. Macon, you have Matthew Baxter. Okay, I'll call it as soon as it's ready. What about Patterson? I'll hold those when they're both ready. I'll get you back up here. Thank you. Mr. Is it Crenshaw?
It's okay, so whenever it's on the initial, this is how we do it.
Mr. Galmore, you have James Rucker. Morning.
How are you?
Morning. All right, good morning. You're James Rucker?
Yes, ma'am.
All right, where are we?
Judge, we've basically completed discovery.
Okay.
We're gonna need a hearing on a motion to quash on one of the indictments. And so,
Okay.
we kind of talked about our schedule and the timing. We were asking for 3 weeks, the week of June 16th, whatever day, if that week is okay.
Has it been filed yet?
It's not, I'll file it probably this afternoon though.
Okay.
And they know what it's gonna say. It's gonna say,
That's the week, we're down the week of the 16th.
Then the week after that, Mr. Nealon will be out for 3 weeks, starting next week, and as a result, I'm covering intake those 3 weeks.
Okay, so just sometime after that, I'll figure out the date.
I am out the next week though. That's the reason.
Just make sure y'all have everything, make sure you've turned in a,
Vacation.
Yes.
I don't know if I have or not. Yes.
if you'll do that, please, that way we can,
Know about it.
well, yeah, because if we know about it, then we can reschedule it. So it's much easier for y'all to do those, get any vacation letters in, including, but we'll look after that date, after the 23rd or 2nd, whatever that is. But whatever days you're out, just make sure that you have that filed, Mr. Galmore, and we'll schedule around that.
Will do.
Okay?
Thank
All right. You're free to go. Stay in touch with Mr. Galmore. He'll let you know when you need to be back.
Yes, ma'am.
Mixing them beat to beat and back to back here at the Courtroom Files Live. Let's go to Judge Boyd with her latest hit. Here's what I always tell people.
Application for probation?
For deferred.
All right, probation, this is an application. Court is calling 2025 CR 002235, State versus Jose Flores. Can I have the parties announce?
Andrew Harris, State.
Phyllis Field for the defense.
And are you Mr. Flores?
Yes, ma'am.
Counsel, have you received all discovery?
I have.
Court will find that the state is in compliance with discovery. Mr. Flores, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, off the record for a moment. Counsel, Mr. Porter, if you could have them move your client down to that end. We're back on the record. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I did, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Flores, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
I did, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Off the record for a moment. Probation. Mr. Payne is here. Are they here to speak with him?
Yes.
All right, thank you. We're back on the record. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
I do, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
I do understand, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's an $800 fine. State recommends deferred adjudication. They'll take in consideration 2025 PF 18009 and 2025 PF 18010. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be a TAP evaluation and community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
I plead guilty, Your Honor.
State any evidence.
To be contained in Exhibit 1 and attachments, Judge.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witness statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just that he's been very cooperative and has taken full responsibility.
All right. So what were you doing on the railroad tracks? Is this drug induced or something else going on?
No, ma'am. I have noticed that there's been an abundance of flora and fauna that has been left decaying on the sides of certain areas down the railroad tracks. And I invented a device that allows the induction of oxygen into the combustion of flora and fauna, which burns at a higher rate for a cleaner burn. What I was trying to do is promote growth through that rate and to help not things kind of catch on. It does look counterproductive in the way that it's done, but it's in the arrangement of rocks and the way that it's made that allows for filtration of oxygen and ambient gases that are flammable. I'm a physicist, so things like that are in my interest for everybody else to kind of be better.
All right, so where did you go to school?
I went to school here at Incarnate Word. I did not complete college, but I consider myself a physicist because of my research in combustion through way of vacuums, basically working through a backdraft system.
So how does this translate into possession of meth and potentially heroin? Because that's what you told them.
That's what I was dabbling with just to keep myself up and pain that I was having.
All right, pain related to what?
Joints, things like that. I don't use very much. I use anywhere from a 0.2 to 0.4 a day.
So where is your family?
I don't have any family that's directly, I just have my wife.
All right, and you say you just have your wife? So how does she feel about the drug use?
She doesn't feel very good about it, but I'm using it.
Do you have any children?
None that are with me.
What are their ages?
I have a 22-year-old who's in the military service, and I have a 16-year-old that's with active service.
All right, and where is your mom, your dad, your siblings?
Both of my parents are deceased. My siblings live in different cities.
When's the last time you had employment?
A few years ago, I also have started doing research with computational emotional AI.
All right, so your previous employment, who did you work for?
Previously, I worked for the Melting Pot as a bartender.
Okay. All right, is there anything else I need to know?
Nothing else.
All right, the court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Does your wife have any children?
She does, but they're grown already.
Are there any minors in the home? No residents with minors. Take in consideration 2025 PF 18009 and 2025 PF 18010. There's an $800 fine that will be probated. Field visits 1 time per month for 6 months. Referral to felony drug court. That will be in custody. They'll see you before the week is out. You need to be honest with them about your drug use. There's to be a TAP evaluation that can be out of custody. Follow recommendations. There's to be 120 sober meetings in 120 days. 200 hours of community service restitution. If he obtains his degree or some type of trade school certificate, the 200 hours of community service will be deemed satisfied. Probation, is there anything else? Is there anything else you need from the court to be successful?
Yeah, Your Honor, I just have one question. So he will be kept in custody until he talks to somebody from the drug court?
Yes.
And how long could he expect to be?
Oh, they'll be done this week. Felony drug court, it's this week.
Before Friday.
Yes. And they'll let us know before then whether or not he's accepted. And he's to be released after he finishes with his drug court evaluation.
Judge, may I approach?
Yes. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, with community service hours, I always give people a chance to use that to better themselves. So it's supposed to be 100 degrees today. Is it gonna be 100 degrees today? I don't know. But usually community service hours may consist of you picking up trash in the 100-degree heat. So you can do that, or you can do either trade school or obtain your degree.
Understand.
And this court, to be successful on probation, communication is key. If for any reason you have an issue, let probation know. If you feel as though they're not addressing it, you can always come back to the court. All right, good luck to you.
Thank you.
You're welcome.
So that guy is perplexing to me. He supposedly has a kid in his 20s and a kid in his teens. He doesn't look old enough for that. So I'm a physicist. Did you go to college? No. What was your last job? Bartender at the Melting Pot. And I pick up trash and decaying stuff along the railroad tracks. I don't know. This sounds like a person who's very lost to me, but maybe I'm wrong. Hopefully he gets stuff figured out. Anyways, let's go back to Judge.
Just tell him to give me 2 minutes. And Mr. Payne, if you'll come down, please. Hello, Mr. Payne.
How you doing?
All right, how are you doing?
All right, definitely, boy.
All right, so Mr. Payne, here are the issues, right?
Yes, sir.
And the state is trying to help you. I'm trying to help you. You've been allowed to stay with your brother, but each time something ends up going wrong, and when something goes wrong, you stop taking your medication. And then I end up with the motion to revoke, because when you stop taking your medication, you don't report to probation, you don't follow through. So there's some sort of breakdown in communication. I don't know if that's with your being with your brother or not.
I left on my own.
I know, see, that's the thing. Whenever you do that, what ends up happening is you don't follow through with probation. So you are looking.
I was gonna follow through. We went to the Center for Healthcare Services. And the one on East Houston.
Mhm.
East Houston and Palmetto, we went there. But my brother took me there. It was my fault, not my brother.
No, here's the thing. I'm not blaming your brother, right? And the reason why I say that is because your brother's not on probation. And at the end of the day, it's really not his responsibility to make sure that you get to your appointments. It's actually yours. However, I understand that there are mental health issues, so you need some help getting to where you need to be. What I'm telling you is, this is not the first time I'm seeing you since I placed you on probation, right? And it's because what ends up happening is your brother will tell you something that you need to do. You decide that you're not going to do it. And then you go downtown in San Antonio and you end up missing for days at a time, months at a time. Probation tries to find you, and then probation finds you. And then we're in this cycle where you're not taking your medications, and then we end up right back here. So I'm trying to stop the cycle of you continuing to go back to jail because you have a motion to revoke. So there are 2 ladies who are in here today. They're with behavioral health. They're going to set up something where hopefully where you can have a case manager.
So that will be somebody who can report to you and make sure that you're taking your medications, make sure that you don't go missing. Because this is a felony court. So when you go missing and you're not on your medication, so many things can happen, right? You can be a danger to others. You could be a danger to yourself. Because sometimes you run into different people, and when you run into different people, you know what ends up happening? Maybe they don't understand you. Maybe they don't want to understand you. Maybe they're just being mean, and they could end up attacking you. And then we're in a whole different situation. All right. So I know you've been in custody because you had to have the competency evaluation and you were found incompetent. Then it took them a while to get your medications correct so that you could become competent and understand everything that's going on. So if I were to release you into the care of your brother, I already know what's going to happen because it's happened in the past approximately 3 times. You go stay with your brother. Everything is great here's the thing, you go stay with your brother, right? Everything's great. And then you leave on your own, which you're an adult, you have a right to leave. But when you leave, you don't return and you stop taking your medications, then you're missing. Then probation is coming to me. They want to file a motion to revoke. And I'm like, no, let's do a compliance hearing to see if we can get him back on track. So they're going to work with you. They're going to work with you to get a case manager. I'm going to bring you back so we can get an update on where they are on that. Okay. And let me ask you this. In the past, has there been any drug use by you? And when you say in the past?
I smoke weed.
Weed, okay. All right. So here's the thing. They may be able to expedite everything because of you're using the weed. It's not going to be a facility necessarily for substance abuse, but it is going to be something to help you with your mental health and help you remain on track, okay? All right, is everything okay at the jail?
Yes, ma'am.
All right, so what we're going to do is, can we bring him back June 3rd as well? I'm sorry? June 2nd. I keep saying the 3rd. Thank you for bringing me out of that. So they're going to bring you back on June 2nd, okay?
Yes, ma'am.
So on June 2nd, we should have some idea where we can get a placement for you, where you can be on your medications, where you can have a case manager to keep track of you. And then you can have your freedom to do everything. But the case manager will just be able to pick up the phone, call you, look for you, stop by, give you your medications. Then you can go, live your life, okay?
Yes, ma'am.
All right. So you have any questions about anything? You sure?
I'm sure, definitely.
Okay.
Let's see. Who, am I going to my brother?
I'm sorry?
Am I going to my brother?
Well, no, what's going to end up happening is they're going to speak to you, right? On June 2nd, hopefully we'll have a case manager for you. And if we have a case manager for you, then it may be appropriate for you to live with your brother. All right. And so what will end up happening is
I ain't gonna live no more, probably.
okay. All right. That's what you said the last time, though.
Cut the grass, I'm gonna wash this, make up my bed, I'm gonna do it.
Well, this is what's going to end up happening. If you end up staying with your brother, you'll still have a case manager to come and see you to make sure you're taking your medications. Okay. All right. So we're going to bring you back on Monday, June 2nd. Okay. All right. Oh.
Thank you.
Oh, thank you so much. You're always so pleasant to talk to. Yes.
Judge Boyd is always so interesting to me. She can kind of fly off the handle at a moment's notice, but then she's got so much patience and compassion sometimes. But, I suppose that's the job and everything is different. Hi, Ellie. Do you want to say hi to people? Yeah? Just a little bit? You need to stay off my keyboard, though. Let's go... Sit down, please. Thank you. Let's go back to Florida and see what's going on there. Nothing's going on there. The judge just left the bench. Let's go back to Judge West.
freely and voluntarily. Find sufficient evidence to find you guilty, but I'm not going to do that. I'm going to follow the agreement that you made with the district attorney. I'm going to defer all proceedings, place you on probation for 3 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. That is going to include being assessed for any special needs that you need, any counseling, whatever it is you need, we're going to have you assessed for that. And if they say you need to go to a counselor or you need it, whatever it is, those are things to help you, and you're going to be required to do them. Do you understand? You'll obviously be required to test regularly. So any type of gummy, any type of anything, doesn't matter if they say in the shop it won't test positive, don't do any of them. Because even if you go buy it legally, I can't know the difference. It's just going to show up on a test. So don't do any of that. If you need some help with something making you feel better, then go through that counseling and do it the right way through a doctor. Okay?
That's what I was gonna tell you. Like, I've been on a medicine that they
Good.
prescribe, like spindle top.
Good.
I just don't like feeling like dead inside when taking it. Like,
I know. And I know there's certain medicines and they don't make you feel
that's
great.
my only thing. I just be
But you
feeling
can't.
disconnected from being a parent.
Right. Well, talk to them about that because there's probably other medicines that they can try.
Yeah, I'm going
Okay.
tomorrow.
But what you don't want to do is stop taking that medicine and then self-medicate with a gummy or something like that. Okay. That's what you can't do. So continue talking to them. Say, I don't like the way this one makes me feel. Let's try something different. And they'll find something that eventually makes you feel right, kind of in a balance. Okay. If you do everything you're supposed to while you're on this probation, this is an excellent opportunity. You don't have criminal history. You're not going to be a convicted felon. If you successfully complete it, the case gets dismissed at the end. You're going to get to be a mom. You're going to get regular jobs, do all the things that everybody else does, okay? The other side of that is if you violate any condition of probation. So if you don't show up for appointments, you test positive, you get arrested or whatever, you can be brought back in here and you can be found guilty, so you would be a convicted felon, and then you could go to the state jail prison for up to 2 years. Do you understand? All right. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Okay?
And I do want to apologize for me over talking to you. That's not my character.
That's okay. You're nervous. I know you're nervous. I know. We're good. All right. Good luck to you, ma'am. Oh, here's the, hold on. I didn't hand this. It's a trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. So just have a seat here in the courtroom and wait for her to call you up.
All right, now we can try Florida again. Judge is back on the bench.
Your Honor, Mr. Hunt has 2 cases going on in county court, and we'd ask that you take a plea as an acting county judge. They're basically time served. In case 251014, the state's filed a felony count of felony battery priors. That's a 3rd-degree felony, punishable up to 5 years in prison, $5,000 fine, or both. He would enter a plea of no contest to that charge, as well as admit that that would cause him to have willfully violated the terms of his supervision in case 231367. The agreement we've reached with the state is he be adjudicated guilty as the VOP. That probation will be revoked. Be sentenced to time served. There's additional $250 cost of prosecution for today's proceedings. That and any unpaid monetary obligations would all be reduced to a civil judgment. On the new case 251014, he'd be adjudicated guilty, be placed on a period of probation not to exceed 60 months, which is the maximum. He'd pay court costs and fines the amount of $1,028. Perform 100 hours of community service work at a minimum of 8 hours a month. $20 a month would remain his cost of supervision. He'd submit to a DNA sample if required, forfeit any seized items. He'd undergo a mental health evaluation and any counseling that's deemed necessary. He would be allowed peaceful contact with Haley Zell. Department of Highway Safety and Motor Vehicles may impose additional penalties, and he would complete an anger management course, specifically the 29-week Batters Intervention course. We stipulate to the facts contained in the information filed under oath. We'd acknowledge that entry of a plea would constitute a willful violation of his probation. We're unaware of any DNA if tested would assist the defense, and we'd waive a reading of any discretionary costs.
That's the agreement with the state?
Yes, Your Honor.
Raise your right hand. Solemnly swear the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, Mr. Hunt, you lower your hand, sir, state your name.
Zachary Hunt.
Hunt, you heard the announcement of Mr. Meredith, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, Your Honor.
Has anybody promised you anything different than what Mr. Meredith just announced in open court?
No, sir.
Are you under the influence of any drugs or alcohol today which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, Your Honor.
I've been handed a plea waiver and consent form. There's the front page. And the second page is the signature of the defendant line. Is that yours?
Yes, Your Honor.
Have you had the opportunity to read this agreement?
Yes.
Have you had the opportunity to go over your VOP and your new charges with
Yes,
Mr.
sir.
Meredith?
Yes, Your Honor.
You had sufficient time to speak with Mr. Meredith about all your cases.
Yes, Your Honor.
Are you satisfied with your lawyer's advice and counsel?
Yes, Your Honor.
You understand that by admitting you violated the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing. And by entering a no contest plea to the new charge, you're waiving your right to go to trial on that case.
Yes, Your Honor.
Are you doing this of your own free will?
Yes, Your Honor.
And you feel the pleas in your best interest?
Yes, sir.
Do you understand you're waiving your right to require the state prove the allegations against you?
Yes, Your Honor.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, Your Honor.
You're waiving your right to present any defenses you might have to the allegation.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which will be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Do you feel, hey, I've already asked you that. And it's, you understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, Your Honor.
I'll accept the stipulation. Find there's a prima facie case on the new case, and I'll find a plea to the new case will serve as a basis for the affidavit or his basis for his admission that he violated the terms and conditions of his probation. I find his pleas were freely and voluntarily made after consultation with his attorney. His probation just going to revoke his probation on the driving license suspended or revoked.
Yes, sir.
On case number 23 CF 1367, his probation is revoked. Or I'll find his admissions and pleas were freely and voluntarily made after consultation with his attorney. I'll accept them. On the violation of probation, his probation is revoked. He's adjudicated guilty of the driving license suspended or revoked. Sentenced to the time he served in the Bay County Jail. Is that correct?
Yes, sir.
And then all monies that were previously imposed and not paid are reduced to a civil judgment. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation. That's also reduced to a civil judgment. In case number 25-1014, he's adjudicated guilty of felony battery prior. He's placed on a term of probation not to exceed 60 months. He's ordered to pay fines and costs of $1,028. There's no restitution applicable in that case. He must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that at the direction of a probation officer. If he's required to give a DNA sample, he must submit one. He'll forfeit any seized items. Also, within the next 30 days, he must undergo a mental health evaluation, follow all recommended counseling. He's to only have peaceful contact with Haley Zelli. Florida Department of Highway Safety and Motor Vehicles may apply additional penalties. He must complete the 29-week batter's intervention program during this course of his probation. Have I left off anything?
I don't believe so.
Now, anger management course, that's covered in the batter's intervention. All right. Mr. Hunt, you have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you and you can't afford one may be appointed to represent you at no charge. Good luck to you, sir. You need to step over, be fingerprinted, and speak with the probation officer.
Things got a little quiet there, so let's go back to Judge Boyd.
A facility would be appropriate, maybe a state hospital.
Well, I don't know, is she still incompetent?
Well, somehow I am, I've been seeing very vision and like evil things in my head. So I'm asking to stay at the one in Dallas, Texas on a rescue
So
facility.
here's the thing. If you've been found incompetent legally, you must be placed into a facility to regain your competency. Legally, I have no control over which facility you will be sent to. So, but it has to be an inpatient facility.
Yes, ma'am.
When I practice, usually that would be the state hospital. So can anybody tell me, is she currently incompetent?
I can think,
I believe based on the information that, and the assessments that have been performed on Ms. Silva, that she is in the incompetent capacity at this point.
All right, because this is dated from 2024. So do we have something today saying that she's still incompetent?
if I get out, please,
All right, Ms. Silva, what I can tell you is you're not going to be released today. And the reason again is because one, when you're found to be incompetent, if it's considered a violent offense, legally, you're supposed to remain in custody until you regain your competency. And that usually involves going to a state hospital.
Because when I went the last time, I was locked up about 2-3 years ago. I got out for like about a year and a half. I was doing okay, and then I was hoping to go to a nun camp or something.
Okay.
I was in probation or something to help me get my mind out of jail so I can learn and get my life back on track.
I understand, and I think that would be great. The only thing about it is legally, if you have a violent offense that you've been found incompetent, legally, you have to go into an inpatient facility. That's not something that I'm making up. That's just what the law says.
Am I supposed to, when I'm seeing things in my eyes, I see evil numbers and like it's trying to kill my son.
Okay.
And I try to pray to God and like I get sidetracked and everything happens to me at once. So I want to learn the Catholic Bible and like fight it back by nun camp. And then I want to go to the Reina Guadalupe for law school to take on prosecution, be a prosecutor.
Hang on, wait till she reviews.
All right, so we're gonna find out what it says. And then Miss Abrams, with her, because she's not currently on probation, I think there was supposed to be an application, but then she was deemed incompetent. So counsel, the two ladies who were here before from behavioral health, if you would like to speak to them and call them,
Okay.
then they can see what can be done. Ms. Abrams, do you have the contact number for them? All right, thank you. So what we'll do is we're going to recall you for June 2nd. Yes. So we're going to put it in the system for June 2nd. It's not going to show up in the system. And the reason why it's not going to show up in the system is because if they have a bed available for you and it shows up in the system that is June 2nd, they won't take you and you're going to fall to the bottom of the list. But just know, if you haven't been transported to inpatient treatment, you're going to be brought back here on June 2nd. And then there are two nice ladies who will come and they'll speak to you and then we'll see if we can expedite things, okay?
Okay.
Thank you so much for your patience.
Can I have the book?
Sure, I'll work with you.
Okay, thank you, ma'am.
All right, you're welcome.
Yes. Thank you, Jess.
You're welcome. And your other client is June 2nd as well.
Great.
You're welcome. Yes.
Okay, I think that's a logical place to leave it for today. I hope you all had fun. I know I did. We got to do our first members-only show this morning. So yeah, if you are not a channel member, consider becoming one. $2.99 a month. Not a whole lot of money, but you get some great extras, and one of them is we now do a pre-show a half an hour before this show starts. And I think we had some fun this morning. We got to learn about a judge from another country who is crazy. And we got to learn about how people don't vote for judges and how maybe that's not a good thing. They should probably vote for judges. Anywho, again, hope you had fun. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for members. Look forward to seeing you all tomorrow. Go have yourself a great Monday. Take care and God bless.